My name's Deputy English. Hey man, the reason I'm pulling you over is your derogatory sticker on the back of your truck. Place your hands behind your back.
For what?
Place your hands behind your back.
For what?
Because you're going to jail, man.
For what?
That is a violation of a Florida state statute, and it is a misdemeanor, okay? Just step back here.
We find ourselves in the beautiful state of Florida, where the sun always shines and you could probably legally own an alligator. Dillon Webbs is driving down the road when a deputy of the Columbia County Sheriff's Office pulled him over for high crimes and misdemeanor. The crime? Having an obscene car decal on the back window that reads, "I eat."
My name's Deputy English. Hey man, the reason I'm pulling you over is your derogatory sticker on the back of your truck. What is that? How's it not derogatory?
The deputy asks Mr. Webbs a very stupid hypothetical question. Mr. Webbs' response is just simply, "That's the parent's job."
So some 10-year-old little kid sitting in the passenger seat of his mama's vehicle looks over and reads that I.E. ass and asks his mom what it means. How's she going to explain that?
That's the parent's job. That's my job.
Okay, let me see your driver's license.
People, we need to stop treating kids like they are fragile china Tupperware. They live in the real world where it is messy, where it might be unpleasant, where people have their own opinions, and it's okay. I see this decal as a benign joke, and it's alright if you don't find it funny or don't like it. It is not there to please any individual person, but Mr. Webbs. In his stop, the deputy claimed the sticker violated Florida Statute 847.011, which deals with possession and distribution of obscene material. He asks for Mr. Webbs' license and registration, and this is where the hunting begins.
That's the parent's job. That's my job.
Okay, let me see your driver's license and your registration. Sir, you got ID on you also? You got anything illegal inside the vehicle, sir? Any drugs, guns, or knives? Large amounts of U.S. currency, dead bodies, or hand grenades? All right, hang tight for me.
This approach screams fishing expedition. Mr. Webbs' predicament brings to light the larger, more profound discussion about the interaction between law enforcement and civilians. It's a reminder of how every word spoken, every action taken, can have far-reaching implications in such encounters. This incident, and others like it, underscore the need for better education for the public about their rights during police interactions, and a comprehensive review of law enforcement procedures to ensure that they are conducted in a manner that respects the rights and dignity of all individuals involved.
Mr. Webb, step out of your vehicle, please. Do you have any weapons on you? Step out. Can I check you for weapons? Turn around.
The deputy came back from checking Mr. Webbs' paperwork and asked him to step out of the vehicle and proceed to check for weapons. Mr. Webbs is clearly confused as to what is going on, and the officer proceeds to tell his life story. He talks about his kids and how furious he would be if one of his kids were to ask him about this particular decal. Listen, buddy, your personal feelings are irrelevant in this situation. The freedom of speech surpasses feelings because we as Americans understand that the right to free speech is bigger than what actually is being said. We might not like it or find it outrageous, ridiculous, ignorant, but the principle trumps all of it. I guess this was never taught to the deputy at the academy.
I have 4 kids. A 14-year-old, a 10-year-old, a 6-year-old, and a 4-month-old. If my 6-year-old was to look at me and be like, "Dad, what does IE ass mean?" Okay, I'd be furious, all right? And the way that we handled this situation, okay, I'm not pleased with. So what I did is I issued you a court date, all right? So you can go explain it to the Columbia County court system.
Mr. Webbs is asked by the deputy to remove one of the letters from the decal. This would infringe on his right to free speech, and unequivocally, Mr. Webbs refuses to do so.
I'm gonna have you take off one of those letters so that the word...
You're not infringing my First Amendment right. You're not doing that. I'm gonna need a copy of your ID too.
It's all on that ticket right there. So, all right, hang tight right there for me then.
The deputy calls what seems to be his supervisor to ask for advice on how he should proceed, and after going over the Florida statute, it is concluded that Mr. Webbs will go to jail and get his vehicle impounded.
All right, Mr. Webb, let me see your hands. Place your hands behind your back.
For what?
Place your hands behind your back.
For what?
Because you're going to jail, man.
For what? For what?
Because I gave you the option to take that off your window, okay? That is a violation of a Florida state statute, and it is a misdemeanor, okay? And then I asked you to take it off, and you refused. So step back here.
Can we get my phone up?
No, you're going to step back here.
Mr. Webbs was arrested for resisting without violence and possession of obscene materials. The charge of resisting without violence to me is the most interesting one, and this is because when a person is charged with resisting arrest, it generally means that they are accused of interfering with a law enforcement officer's attempt to arrest them. There are 2 ways according to the law. This can happen in physical acts such as running away, struggling against handcuffs, or fighting off the officer, but it can also encompass non-physical actions like giving false information, verbally threatening the officer, or refusing to comply with instructions.
Okay, your son's going to jail So he has these obscene words on the back of his truck that says IE asked. Okay. I wrote him a notice to appear so that he could go explain it to a judge.
Okay.
I gave him the opportunity to remove one of the letters so that it was no longer obscene. Okay, he refused.
Okay.
And whenever I asked him to do it, he was resisting, and so he's getting charged with obscene riding on a vehicle and resisting.
Mr. Webbs would be bonded the next day for $2,500, but eventually Assistant State Attorney John Foster Durrett stated that all charges against Dillon Webbs have been dropped, and that his I eat sticker is in fact protected by the First Amendment. He stated that it was very unlikely that a jury would not convict under these facts. Mr. Webbs was returned to him, interestingly, with the decal still attached to the vehicle. So the question is, if the First Amendment doesn't protect obscenities, should this decal be illegal? Well, no. See, because the interpretation of the phrase, I eat, can be interpreted in many different ways, such as flatter your superior, or that the food you eat is bad, or it could be a sexual act. But I'll be upfront about this. Even if Mr. Webbs insinuated this in a sexual manner, I still would be okay with it. Mr. Webbs found himself with no other recourse but to file a lawsuit against the department. He was seeking justice for an arrest he firmly believed was carried out unlawfully, an arrest that shook his confidence in the justice system he once trusted. This was not a casual, knee-jerk reaction, but rather a move born out of sheer frustration and what he perceived as the constant disregard of law enforcement toward the principles ingrained within the Constitution and the Bill of Rights. The call for the police to be held accountable for their actions, for their mistakes, had never been more urgent or pertinent. Sadly, this cry for justice and accountability more often than not fell on deaf ears. A judge, whose task it was to weigh the facts impartially, eventually ruled that the officer in question was protected under a widely contested and controversial doctrine known as qualified immunity. Qualified immunity is a legal concept that provides a kind of protective shield for certain government officials, including law enforcement officers. It's meant to protect them from frivolous lawsuits if they're performing their job duties, as long as they didn't violate a person's rights in a way that's been clearly defined as unconstitutional in prior court cases. There are downsides to this system, however. Critics argue that qualified immunity can allow officials to get away with misconduct. For example, police officers who conducted an illegal search, destroyed a man's car, or even blew up a man's home during a raid on the wrong house have been shielded from lawsuits by qualified immunity. Also, there's a catch. The right that was violated has to have been clearly established at the time of the incident. In Webbs's case, there was a Supreme Court decision that might have supported his lawsuit, but it was made 3 weeks after his arrest, which made it inapplicable. Overall, qualified immunity is a controversial legal doctrine. While it's meant to protect government officials from frivolous lawsuits, critics argue it often shields them from accountability and can prevent citizens from seeking justice for their violated rights. Following this decision, Mr. Webbs found himself ensnared in a system that offered him little in terms of recourse. The ruling effectively blocked his ability to seek damages for what he and many others saw as an instance of clear-cut, unlawful detainment. Left with little more than a sense of injustice and a legal bill, Mr. Webbs' story serves as a chilling reminder of the gaps that exist within our justice system and the urgent need to address these for a fairer future.